Be ready? Start. To operate the account in the capacity of the manager of the institution, stop. The district inspector of schools Manipur, it appears, had developed cold feet when notice for contempt was issued and had passed the order on 20th February 2010, cancelling his order dated 30th December 2009, which is to safeguard his personal interest. Stop. We are therefore of the considered opinion that the learned single judge had rightly stayed the operation of the order dated 20th February 2010, which does not call for interference. Stop. The special appeal fails and is dismissed. Stop. Stanza. In the light of the aforesaid decisions, the court finds that the intelligence report was provided by the respondents to the petitioner pursuant to the interim order of the court. Stop. The grievance committee has provided full opportunity to the petitioner and he was put to notice of his past antecedents. Also. Stop. The court finds that the petitioner was questioned on all the findings given in the intelligence report. Stop. The grievance committee records the admission of the petitioner with regard to the past antecedents and also records his presence at various places mentioned in the intelligence report on the night of the incident in question. Stop. The grievance committee concluded that the petitioner had made contradictory statements and that the certificates issued by the police authorities was not reliable. Stop. The grievance committee found that the charges leveled against the petitioner were correct. Stop. The antecedents of the petitioner was also found to be correct. Stop. Consequently, the court is of the opinion that the principles of natural justice stood fully complied with and the prejudice which was initially caused to the petitioner stood removed after the appellate authority provided an opportunity of hearing. Stop. Stanza. This court has also considered the stand taken by the petitioner, namely that he was not involved in the incident nor was present. Stop. He alleges that he was sleeping the whole night in his room but subsequently comes up with an alibi that he was helping the police authorities in maintaining peace and harmony with the students. Stop. The statements made by the petitioner from time to time is contradictory and does not support the petitioner's case, and on the basis the certificates issued by the police authorities becomes unreliable. Stop. On one hand, the petitioner states that he was in his room the whole night, and on the other hand, the certificate indicates that he was helping the police the whole night. Stop. These two facts are contradictory and cannot go side by side. Stop. The disciplinary authority as well as the appellate authority were justified in discarding the evidence given by the petitioner. Stop. It is incorrect to state that the evidence provided by the petitioner was not considered by the authorities. Stop. The court finds that the disciplinary authority as well as the appellate authority has given reasons for rejecting the certificates issued by the police. Stop. Stanza. A feeble submission was made by the learned counsel that the police authorities has also submitted a final report absolving the petitioner from the incident. Stop. On a close scrutiny of the document and upon placing a query upon the learned counsel for the petitioner, the court finds that a letter written by the police authorities could not be taken into account in as much as the police investigation is still going on and that no final report has been submitted in the court as yet, nor any such report has been accepted by the court concerned. Stop. In any case, criminal proceedings and departmental proceedings stand on different footings. Stop. In criminal proceedings, the degree of proof is different than that in a domestic proceedings. Stop. It is well settled principle of law that in a departmental inquiry, a finding can be recorded in preponderance of probabilities, and it is not necessary that the charge must be proved to the hilt. Stop. The departmental proceedings and criminal proceedings are entirely different in nature. Stop. They operate in different fields and have different objectives. Stop. The evidence in a departmental proceedings may be irrelevant in a criminal proceedings. Stop. The rules relating to the appreciation of evidence in a departmental proceeding is different than that in a criminal proceeding. Stop. Similarly, the degree of proof is different as held in Abhiraj Singh versus Bank of Baroda and another 2005 SCC. Stop. Stencha. Learned counsel for the petitioner submitted that when the period of transfer has been extended for another period of 3 years by the director vide its order dated 24/5/2011, there was no occasion for the district magistrate Firozabad to recall the petitioner before expiry of the said period. Stop. He submitted that the cancellation order dated 7/9/2012, by which the earlier order dated 24/5/2011 has been cancelled, in connoted and manipulated. Stop. Though in the earlier letters and orders the dispatch numbers are mentioned, but in the present order no dispatch number is mentioned. Stop. The said order has been passed after filling of the writ petition by manipulation, and therefore all the impugned orders are liable to be quashed. Stop. Shri Pankaj Rai, learned additional chief standing counsel, submitted that the petitioner was transferred for a period of 2 years only. Stop. In the appointment letter, it was specifically mentioned that the appointment was temporary and the lien would be in the parent department, and in case there would be no need, without any notice, he can be returned by the director. Stop. When the petitioner was transferred for a period of 2 years only, there was no occasion to extend further period by the director. Stop. In any view of the matter, when the district magistrate vide his letter dated 6/8/2012 written to the director has informed that there is a shortage of employees in the Koshagar and requested for the release of the petitioner, the director acted upon the letter, and by the letter dated 11/9/2002 has released the petitioner. Stop. The order of the director dated 11/9/2012 is in consonance with the term and condition of the appointment letter dated 26/6/2009, wherein it was categorically stated that in case of no need, without any prior notice, the director can direct for the return to the parent department. Stop. In pursuance thereof, the additional director, treasury and pension, Agra zone, Agra, in whose office the petitioner was working, has also relieved the petitioner. Stop. As per the appointment letter, even after transfer, his lien was in parent department, and therefore the petitioner has no legal right to claim his appointment and continuity of his service in the pension secretariat. Stop. He submitted that it is absolutely wrong that the order dated 7/9/2012 is connoted and manipulated. Stop. Merely because the dispatch number is not mentioned, the validity of the existence of the order cannot be disputed. Stop. He submitted that even the order dated 7/9/2012 may be ignored. The order of director relieving the petitioner was in accordance to term of the appointment letter dated 26/6/2009, and therefore the petitioner cannot claim his legal right to continue in the pension directorate. Stop. I do not find any merit in the claim of the petitioner. Stop. The petitioner was a regular employee in the office of Koshagar under the control of the District Magistrate Firozabad stop. By the appointment letter dated 26/6/2009, the petitioner has been appointed and transferred to the office of Additional Director, Treasury and Pension, Agra Zone, Agra stop. Over.